Welcome to an all-new franchise on Talking Feds, Talking Feds One-on-One. I'm your host, Harry Littman. Each week, I'll be sitting down with some of the most interesting people in the country for in-depth discussions about the most fascinating and consequential issues in our world. We'll cover everything from politics and law to science, history, sports, the arts, and a ton more, diving into issues that define our culture and shape our lives. And I think having a lot of fun in the process. Let's jump in with our first Talking Feds One-on-One, a conversation with Judge Michael Luttig. Hi, everyone. I'm Harry Littman, the host of Talking Feds, and today I'm talking with somebody who has a rocket fuel resume, clerk to Antonin Scalia, clerk to Chief Justice Warren Burger, Assistant Attorney General at the Office of Legal Counsel, the brain trust of DOJ, the youngest appeals judge in the country when he joined the Fourth Circuit at age 37, and thereafter general counsel at Boeing. Time permitting, he's going to tell us all about the Starliner. I'm, of course, talking about Judge J. Michael Luttig, who in the past few years has added maybe a surprising entry to his resume, namely pretty staunch critic of President Trump and the current Supreme Court. He famously advised Vice President Pence in the lead up to January 6th that it was the vice president's constitutional duty under the 12th Amendment to open the votes as delivered to the Senate for Joseph Biden. And I think others here are old enough like I to have seen It's a Wonderful Life. So just in It's a Wonderful Lifestyle, imagine for a moment where we might be today had he not. So I give you Judge J. Michael Luttig. Hello.
Hello.
So our topic today is the vibrancy and vulnerability of the Constitution. We learn a lot in third grade and later about the vibrancy of the Constitution. There's a kind of almost worship of the founders for having created this lockbox in the 18th century, and it's served us all this long. We haven't been accustomed to thinking about the Constitution's vulnerability. So let me just start by putting it to you. How vulnerable do you think the Constitution is as we sit here, and why now? Why haven't we noticed the flaws before?
As you may have heard, I endorsed Kamala Harris for the presidency. And of course, I did so in a 5.5-page single-spaced.
Did you have a clerk draft it?
No.
No.
Although my clerks used to say that clarity was not the judge's problem. And they misunderstood their role, which they thought was to obfuscate my clarity. But now I realize I have to put on my reading glasses. In that 5.5-page letter, I included these passages. The founders of our nation and the framers of our Constitution feared most of all this very moment in American history, when the American people would be tempted by the seductive demagoguery of a modern-day populist demagogue. In a letter to George Washington in 1792, over 230 years ago, Alexander Hamilton warned of this day and this demagogue who would, quote, mount the hobby horse of popularity and whose objects, quote, may justly be suspected to throw things into confusion, that he may ride the storm and direct the whirlwind. Thomas Jefferson agreed with Alexander Hamilton about very little. except about the existential danger to the republic of a populist demagogue. Quote, if once elected and at a second or third election outvoted by 1 or 2 votes, he will pretend false votes, foul play, hold possession of the reins of government, be supported by the states voting for him, Thomas Jefferson presciently wrote to James Madison in 1787. Those are remarkable warnings from our founding fathers and the framers of our Constitution. Prescient. Our founding fathers feared this moment and this man more than anything else at the time that they founded this nation and wrote our Constitution. So, with that segue and anticipating your question, the Constitution of the United States itself, as the charter of our nation, is not vulnerable at all. It was genius, literally genius. It was written to endure for all eternity, including, of course, the possibility of amendment, as the Constitution has been amended. But no Constitution, and not our Constitution, can protect us, the people, from those public officials who occupy the highest positions of our government for the people. Has our Constitution prevailed today under the circumstances beginning on January 6, 2021? The Constitution has, yes, without any doubt. But those charged with enforcing, if you will, the Constitution, for the most part, have failed us. And that's where I'd like to begin the discussion today.
Perfect. Thank you. And it really is, chillingly prescient. You read that in other passages, and it's like the picture of Trump emerges. But let me follow up in just the way you were going, Judge, because there's 2 hypotheses here. One is that Trump is the singular demagogue whom Jefferson and Hamilton feared. The other is that there have been would-be demagogues dotted, over the landscape in the course of history. And there's something about today's political landscape, our politics, our party system, our courts, that in fact have brought us to this precipice. And I note, by the way, Jefferson's especially sobering second term, right? The particular worries if we're in a place where there's no standing for election. So I guess the question is it, Trump, the person that you ascribe to this cataclysmic moment, or more so the whole political landscape that has not stepped up the way some people have?
Well, as we lawyers are fond of saying, and Donald Trump is the but-for cause. Donald Trump is the but-for cause for the corruption of America's democracy, the Constitution, and the rule of law, for reasons that we all know, even the Republicans know. This man, for the first time in American history, attempted to overturn an election that he had lost fair and square by a vote of the American people. From that day to this day, he has denied that fact, and he's defied Americans' democracy, Constitution, and the rule of law, to the point now that he is on the verge of possibly being elected to the presidency of the United States of America again. All of this enabled by his Republican Party. And you know where I'm going with that. There is no Republican Party in America today. It is a party of one man, Donald Trump. And as a consequence, the so-called Republican Party stands for nothing at all except its own preservation under the authority of Donald Trump. Now, we can't have a democracy in America unless there are two robust, healthy political parties. And today, we have only one political party. As I said elsewhere, had a lot of opportunity to say whatever I wanted to in that 5.5-page type letter. And I still didn't get all in what I wanted. But in what became judges don't speak in sound bites, and I don't either. But one of the 400 sound bites in that 5.5-page letter was this, something to this effect: there is only one political party in America today, and only one candidate for the presidency of the United States of America who can claim the mantle of protector and defender of America's democracy, the Constitution, and the rule of law. And as a consequence, I will unhesitatingly vote for the Vice President Kamala Harris. Emphasis on the first part of that. I assert that as a fact. And I defy anyone in this country to deny that fact based upon the past 4 years. Now, never before in American history, almost 250 years, has there not been a peaceful transfer of power. The peaceful transfer of power, is literally one of the fundamental tenets, if not the most fundamental tenet of American democracy and the Constitution of the United States. I mean, just pause for a moment and reflect on what we have today. The circumstance where the Republican Party and the current nominee, standard bearer for the Republican Party, tried to overturn the last presidential election, declares proudly, with the support of his party, that he will not accept the results of this election in November unless, of course, he wins. And every Republican official supports him in that. That is catastrophic for the United States of America. This cannot be. That's just a matter of political but constitutional fact.
Yeah, and I just want to say that your bona fides may, as the ovation you got at the beginning really demonstrates, make that all the more eloquent and emphatic. People who haven't known you before the last year or two might be forgiven for thinking your first name is conservative, because you're always introduced as conservative Judge Michael Luttig. And in fact, 25 years ago, this is from the New York Times, Michael Luttig is a conservative, an idol of the conservative legal movement today. My sense is that you're very happy to wear that banner still, and you. It's either consistent with everything you're saying or maybe even part of what drives what you're saying. Is that fair?
Well, it's fair, but it's also not the most important thing you could have said, Harry.
Oh, let's rewind. What's your side? No,
to report that, as the Trump people are fond of saying, the former conservative Judge J. Michael Luttig says. Look, of course I'm conservative. I've always been. I was born conservative. And by the way, I was born conservative just up the road from here in Tyler, Texas. And while I'm on that, in a more serious vein, I learned everything about life and everything that I know today growing up in Tyler, Texas. And I dare say I learned every single thing that all of you in this room learned, okay? You haven't changed in the 50 or 60 or 70 years, and I haven't changed in 60 or 70 years, one iota. What's changed is the Republican Party and Donald Trump. They are in an effort right now to change every single thing that all of us were taught and believe in, and more importantly, to change everything that America stands for. So the headline, in a nod to the quasi-political nature of this gathering, the festival, the news, Harry, is that, of course, I'm still proud to be a conservative, but today, and I've said publicly only one other time, if Donald Trump and the Republican Party want to call me a Democrat or a rhino, or, since I endorse Kamala Harris, a communist, then my response to them is, if I'm a Democrat, I'm a proud Democrat.
Respectfully, I think I have to say you salvaged the importance of my question, and it was where I was going. I'd like to move now a little bit to the courts, where you spend much of your career and your focus has been, and we can maybe employ this maybe too often employed concept of liberal versus conservative. But let me just ask a general question or two before we move to some of the cases that have so alarmed you, really. I want to start with this somewhat famous meme that the Chief Justice launched during his confirmation hearings of a judge as an umpire, sort of suggesting, if you look close, you can always see the ball and the strike. Do you endorse that concept of a judge?
Well, the Chief Justice was and still is to this day a very good friend. It's a matter of public record that the Chief Justice and I interviewed with President Bush back to back, 1 hour to the next, back in 2005. But when John said that publicly, I don't remember it, and I don't even know what you said. You said a meme or something. I don't know what that is, but
that's a college word. Okay. A meme. Yeah.
But I really don't know what that means. But
a word that gets cultural purchase.
Okay. But I was bewildered. I didn't even know what Judge Roberts was even talking about. And I don't know what he's talking about today. Those words would never have passed my lips in talking about the judicial role and the judicial function. I mean, you're a lot smarter than he and I both. Ask yourself, what it means for a judge to be an umpire. First off, I don't even want to get into it because it would be meaningless, but the judge enforces the constitutional rules and the laws of the United States. To my lights, any reference of the judicial role to the game of baseball is trivializing the judicial role.
Fair enough. Okay, I want to zero in on a few of the cases from the last couple years, because in addition to your very, I think, insightful and far-reaching critique of broader concepts like democracy and the rule of law, we've seen you quite a bit in very specific criticisms of very specific fact patterns in cases, and indeed you've been parties to cases in front of the Supreme Court. If I could, let's start with the insurrection case. That was the 14th Amendment, Section 3 case in which Colorado had decided that by virtue of the constitutional provision, Donald Trump could not be on the ballot. And it went up to the Supreme Court, and they overruled. I'll just say that. Let me just ask you, how would you have decided that case and why?
I would have decided it in accordance and under the Constitution of the United States of America. Yeah. And let me explain. Section 3 of the 14th Amendment, first off, despite what was said at the time by Trump and his followers, is actually part of the Constitution of the United States. Their first argument was that it was an anachronism that there is no anachronism in the Constitution of the United States.
There's a meme.
Well, then so be it. But in the plainest language possible, Section 3 said that any person who previously has taken an oath to support the Constitution of the United States and thereafter engages in an insurrection not against the United States, but against the Constitution of the United States, shall never hold high office again, including the presidency. And for another day, we could go into it. But every single element of constitutional history, legal history, the debates around the 14th Amendment confirmed, and not one piece of evidence confirmed differently, that Donald Trump had engaged in an insurrection against the Constitution of the United States of America by trying to remain in office in violation of the executive vesting clause of the Constitution beyond the term to which he had been elected by the American people. It is impossible to frame a clearer case for disqualification of any person from high office under Section 3. Thank you, and I mean this is your Constitution. It's our, we the people, it's our Constitution. The Supreme Court. So I was listening to the 3-hour argument, and in that argument, and we're going to get to the immunity argument later, the Supreme Court of the United States barely asked one single question in 3 hours of oral argument about the case. Barely a single question. And I said immediately thereafter, the Supreme Court came into the argument knowing that it would never decide the issue. And of course, it didn't. And weeks or months later, it came out with an embarrassing per curiam opinion, every word of which was unsupported by the Constitution and laws of the United States, saying in so many words, we're not going to decide this. We don't really know who should, so we're just going to kick it over to the Congress of the United States. And then I'm adding this to the opinion because we know they'll never be able to figure it out. And the more liberal justices on the Supreme Court didn't distinguish themselves either, though they wrote what they termed a concurring opinion, which was a misnomer, a judicial misnomer. It was, if anything, a dissent. But they did say this, and think about these words coming from the Supreme Court of the United States. And I think it was Justice Kagan. I fear today that the Supreme Court today decides this case in order to protect one man. That tells the whole story of that case. That is just one of the ways in which Donald Trump has corrupted American democracy and the rule of law. But let me explain the democracy point of it. The most offensive thing, no, it wasn't offensive. It was understandable, but I was offended to the point that I don't usually call television people, right? I mean, I'm trying to hide from them. But some of the leading national journalists were claiming before the case was argued that it would be anti-democratic to disqualify Donald Trump from the presidency. And I called a couple of my friends and I said, I have something to say. And they said, fine, come say it. And I did. And what I said was this. I said, the disqualification under Section 3 of the 14th Amendment is anything but anti-democratic. It is the Constitution itself that tells us that an insurrection against the Constitution of the United States is anti-democratic. I was gravely concerned. And reading between the lines, though you don't have to read much between the lines, and there are not many lines to read between, in the court's opinion, the court believed that it would be anti-democratic to disqualify the President of the United States. And to that extent, and to whatever other extent involved, I said that after the decision that with my dear friend, Lawrence Tribe, the Supreme Court had betrayed the Constitution and America.
I want to follow up here briefly because Justice Kagan, among others, you could see the court was very, very concerned that were they to rule for Colorado, it would sow chaos in the country because there could be a sort of patchwork result. Let's assume that was a valid supposition. Is there any role that something like that should play in the decision?
That's a softball. I thought higher of you before.
Some high heat is coming, don't worry.
So this is the high inside fastball, okay?
Set you up.
That argument, when it was made in the Supreme Court chamber, was perhaps the most sophistic, do you know the word sophistry? Sophistic constitutional argument ever made in the Supreme Court chamber for this reason. It was the responsibility and obligation under the Constitution of the United States for the Supreme Court to decide the question.
Right.
It's a constitution we are expounding.
And if the court had decided the case, there would have been no chaos whatsoever. When I heard that question, I just about jumped through my transistor radio.
Fair enough. I just want to say that this is one of the things that are challenging courts today. Just yesterday, Justice Merchan in New York, you could see people wrestling with what they see as the singular historical times and fraught with complexities that we're in. And it's a challenge, or that for some judges, I'll just leave it at that. I'm glad you didn't jump through your transistor radio because you wouldn't have had anything left to do when the immunity case came down, which you called an abomination at the time. And I'll say this about, we continue to experience the aftershocks and the impact on all our sort of political life of that opinion. Abomination, that's what I want to focus on. It seems to take it out of the category of just wrong or even grievously wrong to sort of historical misstep along the lines of, we don't have to, go to 100 here or 11, Dred Scott say, but you choose your words very carefully. I think it's clear to all of us now. So, abomination, explain, please.
Well, first off, seriously, the highest honor that anyone could ever pay to me my entire life is and has been that I choose my words carefully. Words and thoughts behind the words are the most important things in my life. And for the past 4 years, I have felt the highest obligation to all of you to choose every single word with absolute precision. So thank you. In an effort to lighten it up just a little bit, I just want to remind all of you who do know and those of you who don't that, my law clerks, John Eastman was the principal architect of the effort to overturn the 2020 presidential election. The 14th Amendment case was argued in the Supreme Court by another of my law clerks, Jonathan Mitchell. And the immunity case, which we're going to come to, was argued by yet another clerk of mine. And actually, it hasn't been hard for me at all. Now that I think about it, I started to say it's been difficult for me, but it's been difficult for my clerks, not for me. But it's been fascinating. So, when the media calls me and says, well, Judge, your clerk's making this argument, I say, well, the only thing I'll say on the record is that I don't really care what my clerks are arguing. But to the immunity decision, and I've spent most of my life studying the presidency and executive power, as Harry mentioned, beginning in the Office of Legal Counsel, probably in the 1800s, and never before in the history of the Republic, to my knowledge, had anyone, let alone a scholar of the Constitution, let alone a Supreme Court justice, let alone a federal judge, ever even suggested that the President of the United States might be immune from prosecution for crimes committed against the United States of America. In 250 years, no one had suggested that. And of course, the very idea is antithetical to the framers of our Constitution, the founding of our fathers. It would go without saying, but it will not today, that we revolted against the crown 250 years ago, the monarchy. So to set up a democracy under the rule of law, under which no man is above the law. The Supreme Court of the United States, as you know, actually held that the one person that the Constitution and our founding fathers said cannot be above the law is above the law. Minutes after that opinion came down, I said, this is an abominable decision. And I looked the word up 5 times before I typed it. And in the same tweet or whatever you call it, I compared it to Dred Scott, to Plessy against Ferguson, and Korematsu, the most ignominious decisions by the Supreme Court in all of history. I later subsequently elaborated on it this way, that I think of the decision as worse than those 3 decisions because, and I want to be sure now that I'm saying it out loud again, because that decision did violence to the structural Constitution in a way that the other 3 did not.
I think that's really perfectly, beautifully put. You don't need me to say that. But, it's interesting. Those other 3 became discredited little by little and all have hit the dustbin of history. One has to wonder, what will be the fate of the immunity opinion. I'd really like to, I want to say one quick thing, which is in support of Judge Luttig's clerks. There may be 1 or 2, but he had the highest, I think still never to be equaled batting average of any judge to every Luttig clerk went to the Supreme Court. So the fact that in a big dispute there on either side or whatever is just par for that course. There's so much more we could say about the immunity opinion, but I'd like to leave a little bit of time for questions. Just let me I wanted to ask you this. It's certainly a big part of, along with other decisions, including Dobbs, but also the Loper Wright, the Chevron decision, a flurry of them all have contributed to the court's extremely low public regard. And I just wonder what your thoughts are. It's it's designed by constitutional design. They're insulated from popular discontent, and they play a counter-majoritarian role. But what do you think are the consequences for the Supreme Court and the democratic rule of law of the courts being held in such low public regard?
I wouldn't, of course, venture a percentage allocation of fault, but a disproportionate, highly disproportionate amount of the disrespect within which the Supreme Court is held by the American people today is attributable to what I have called self-inflicted wounds. The Senate Judiciary Committee called me one day. I was leaving Washington, which is what I always try to do. And I always try not to go to Washington in the first place. But they called and they said, well, Judge, this is Senate Judiciary Committee. And I said, what do you want? And they said, well, we're here to help you. No. But no, I said, well, what would you like? And they said, well, we'd like for you to come testify in support of ethical standards for the Supreme Court of the United States. And I said, well, I'll think about it, and let's talk tomorrow. And we talked the next day, and I said, so what is this hearing going to be like? And they said, well, Judge, we kind of have to tell you the truth. It's probably going to be a circus and a food fight. And I said, well, that's kind of what I thought too. And if you'll, as we say in Texas, if you'll allow me, I'm just not going to come. And but I did agree to write testimony, which I believe will be the most important words that I've ever written, when I pass from this life. Important to me because I was speaking not just to the American people, but to the Supreme Court of the United States. And I said the Supreme Court should want to be restrained or constrained by the highest ethical standards such that its non-judicial, extrajudicial conduct is beyond reproach in all respects, because according to the Constitution and our founding fathers, the Supreme Court's credibility, ultimate credibility, and therefore the respect with which its judgments are accorded by the American people is dependent in part, and in much part, also on the way in which the members of the Supreme Court conduct themselves off the bench. And of course, we're beginning to see some members of the court come out, Judge Jackson most recently, saying, in my words, of course the Supreme Court should be bound by, ethical standards. I don't even understand what they're thinking, what they're doing, but I have no respect for their argument that they're above the American people.
So many well-chosen words. Please join me in thanking Judge J. Michael Luttig. Thank you for tuning in to One on One, a weekly conversation series from Talking Feds. If you like what you've heard, please tell a friend to subscribe to us on Apple Podcasts or wherever they get their podcasts, and please take a moment to rate and review this podcast. You can also subscribe to us on YouTube, where we post full episodes, talking books, and bonus video content. To catch the Q&A from this discussion, head over to our Patreon, where you can find other bonus content as well. Talking Feds remains one of the very few independent productions out there, so if you like the work we do and are inclined to support the show, joining our Patreon is the best way to do it. Plus, you'll get tons of perks like free access to my LA Times op-eds and the chance to join monthly live Q&A sessions. Thanks for tuning in, and don't worry, as long as you need answers, the Feds will keep talking. Talking Feds One-on-One is produced by Catherine Devine, associate producer Gabriella Glick, sound engineering by Matt McArdle, Rosie Dawn Griffin, Hamza Mehendranathan, David Lieberman, and Emma Maynard are our contributing writers. Production assistance by Akshaj Turbailu and Genesis Magpayo. Our music, as ever, is by the amazing Philip Glass. Talking Feds is a production of Delito LLC. I'm Harry Littman. Talk to you later.